Hello, everyone. Welcome to another episode with Legally Wired. On this episode of Legally Wired, I'm going to take you through how to think like a lawyer. If you do this right, you will enjoy being a lawyer because being a lawyer is all about problem solving and helping your clients make better decisions. I've been a practicing corporate lawyer for nearly 10 years, and I'm going to take you through a day in the life of decision making for a corporate lawyer. So let's get on to the screen and look how we do this. So in this video, we're going to look at how it is to think like a corporate lawyer. And this is essentially a good part of what a corporate lawyer at a transactional law firm does. Okay. Let's start with a standard fact pattern. So disclaimer, the fact pattern is a normal fact pattern that you would see at any transactional law firm, but some of the details may be slightly exaggerated just to drive home a certain point. Okay, so let's assume that there are two companies. I'm going to draw a box here, company A, and this is box B. Okay, and both, let's assume that A and B are in the food tech space. Think Zomato, Swiggy, right? Let's assume that A is a veteran company in the food tech space. They've been in the business for over 30 years, right? And everybody in the market knows them. And B has come alive in the year 2023, right? Last year was, so they're still a startup. Last year, that is financial year 2024-25, was their best year. They hit a 10 million revenue target. They have a great management team. And a great revenue team. Sorry, a great marketing team. And a great app. The founder and CEO of B is Mr. Alex, another hypothetical name, right? Okay, so A likes B. A wants to buy 100% of B, right? It wants to buy all of Alex's and a few other investors' stock in B and own B 100%. Why? Because they have a great team, great management, great marketing team, and great app, right? So for all these three reasons, they want to buy, and plus proof of concept. Within 3 years, and in 24-25, they've hit a record year of 10 million in revenue. So they want to enter into a deal to buy B. So what would A do in the ordinary course? A would go, they would hire a law firm. Okay, so for law firm, let's do a small tower. I'm just kind of drawing a visual of the firm that I worked in. This is how it looked. Like a tower. So A would go hire a firm, and then the law firm would conduct diligence of B before the transaction. Before A bought B, a due diligence would be conducted of B. And obviously the reason why they want to do the due diligence is, one, to verify if all of this is factually correct. That is, great marketing team, the revenue of 10 million, relevant contracts to show that they've got that revenue of 10 million. I mean, and they can go verify the customers. They can go verify all sorts of facts that B is making about the business, or Alex is making about the business, right? They can also, they will do an IP diligence of this great app, make sure it has all the requisite trademarks, copyright protections, etc. So the law firm conducts the diligence and it releases a report, right, which goes to A. And it identifies three important things. One, the app not owned by B, but an other related entity to B, right? We'll get to that. Number two, company law, compliances not done, right? So, and then three, let's say that consultants misclassified as employees. So it's not that A is not going to buy B because of these three issues. A is definitely going to buy B. All of these issues are fixable. And that's where a corporate lawyer comes in. A corporate lawyer's job is to assess the level of risk involved in each of these issues and then suggest an appropriate course of action either prior to the transaction closing, which is called a condition precedent. It simply means that fix this issue before we transfer the funds, right? Or they may assess the issue and come to the conclusion that this is not really a big red flag items and this can be solved for after the transaction is complete. Or they may also, sometimes you may get some very big issues where the transaction cannot happen in the first place, right? For example, the first issue, app not owned by B, let's just consider that the second statement is not true and the app is not owned by B and there's another company X. X owns Big Byte app. Super efficient, works seamlessly, better than what A has currently, and X licenses the app to B. It's a general license. X licensed the same app to a lot of other companies globally, right? And that's an issue, right? So if this is the case, then A may not buy B. Okay. Before we go further, let's assume that the price for buying B is 100 million. Normally, tech companies get close to 10x valuation. Revenue is 10, so that's why we went with 100 million, right? So in this 100 million valuation, a good part of that valuation would be for the tech, because ultimately A is an established company. They're not buying B for the great management team and the great marketing team. They're buying B because they believe B has a successful product, which is the bite-size app, and they want that app along with the management team. They want to integrate the whole system into their business, and that's why they're buying B. If that app itself, which is the most fundamental asset that they're looking at acquiring, does not exist, or if it is owned by another entity X, which is licensing it to B, then A may not go ahead with the deal. It's a super big red flag, right? Because X may just cancel off this license. They may not renew the license. Then what? Then B doesn't have an app, and A is just buying a box with employees for 100 million. So these are very important points. But anyway, that was not the fact pattern we were looking at. As for per our hypothetical DD report, the fact pattern was X is related entity to B. What do I mean by that? Let's assume that Alex, when developed the Big Byte app when he was in college, and at the time of developing the app, he incorporated company X. His idea was to license it to other entities who can then run their own food tech business, and then he just makes a license fee each time he licensed the app out. But instead, he built his own company, B, and he executed an exclusive license agreement with B with the intent that only B gets the sole and exclusive right to use the Big Byte app. So this issue is fixable, right? And this is where thinking like a lawyer comes, right? So let's say that A's law firm is looking at this issue. So A's law firm's position would be, couldn't care less about how you do it, but if you want our 100 million, make sure that X transfer all of the underlying tech in the Big Byte app to B, right? They just have to no license. They just have to assign all of the underlying. If there's any copyright trademark attached, all of it has to be transferred into B's name. So effectively, B will own all the rights to the Big Byte app. So that's fairly simple. But let's say that you are Alex's lawyer, right? And you're looking at this deal. Now and Alex owns 100% of X, right? So what happens? X essentially has one big asset, Big Byte app. And if you look at the value of that asset, if you do a fair market value of this asset, it would be quite substantial. So when X transfers this asset to B, there will be a capital gains tax that Alex has to take care of, or X, the company, has to take care of. So there will be a capital gains tax that X has to take care of. There could be other relevant tax related issues on that transfer, because what Alex is likely to do is he will transfer this Big Byte app, because these are related entity and Alex is the owner here, Alex is the owner there. So he might just transfer the entire tech to B without any consideration. But the problem is the way the government looks at these transactions, even if you transfer it as zero, is that these are transfer pricing related issues. What that means is that you've transferred technology between two related entities. The government will still look at the fair market value of that asset that you transferred, and they will still expect you to pay capital gains, assuming that you've transferred it at the fair market value. So even though you're not getting any money for this transaction, Alex still has an obligation to pay capital gains on the fair market value of the Big Byte app. So this is something that Alex might want to mitigate. So their lawyers may come with a whole set of proposals. Their tax lawyers in particular. One, they may propose that X exclusively licenses this tech to B, right? And obviously this will be rejected by A. Why? Because exclusive license still doesn't mean ownership. And A will want full ownership on this Big Byte app. That's the reason why they're buying the company. Right, so there are other creative ways which you can do it, but it's too complicated. And the idea was to kind of show you the kind of angles that a lawyer will think about each of these issues. Each lawyer, depending on whose perspective they're going to represent. The most easiest perspective is A's perspective, where all they're going to tell B is until this tech is fully transferred to us, there's no transaction. We're not going to do the 100 million until this entire tech is transferred to B. Now, B's lawyer, assuming that they found a way to effectively transfer the tech between X and B, will say, fine, we'll undergo this entire process, but we will want deal certainty. That, okay, if we do this deal, what is the guarantee that you're not going to back out, right? That's a very important concept. Right? B always wants deal certainty. They want certainty that they're going to get the 100 million. So they probably execute an agreement where it would say that A will transfer 100 million to B for 100% of B's shares, provided that B finds a way to purchase all of the tech in X, and that purchase has to be verified and approved by A's lawyers. Let's not go into the mechanics of how these clauses are drafted in an agreement. We can look at those things in another video. I just want you to get a sense of how these things work and how these things are thought of, right? So this is how this issue would be dealt with. Now, on company law compliances, this is where A and B's lawyers would go through each non-compliance and first understand how bad is it. When I say how bad is it, I mean, what is the cost of non-compliance? Is the cost a simple fine, or does that also include imprisonment, right? So if you look at the Companies Act non-compliances, they are largely in two parts. Either you just pay a fine and regularize it, or sometimes directors can get arrested. In very few times, I must caveat that by saying only in a very limited number of circumstances do directors get arrested. So if it is largely fines, then A and B would agree in two ways, right? They could, if they're a lot more flexible and practical, they could say that, well, we don't have to wait for this action to complete to close the transaction. Of the 1 billion, we will hold back the aggregate value of the total fines that the Ministry of Corporate Affairs or whatever authority in whichever jurisdiction they are is going to charge. So let's say that number is close to $1,000. So it'd be the deal $100, $1,000 from would be held back to take care of those fines. Right? That's an approach that will fix this problem. Or A's lawyers could also say, we don't care, finish all of the compliances, show us that you've completed all of those compliances. We'll definitely give you deal certainty that the moment you show us that you've completed all these non-compliances, the 100 million will be transferred over to you, right? And then finally, this third issue of consultants misclassified as employees. So sometimes what happens, companies hire people as consultants, but they end up exercising a sufficient degree of control and supervision over those consultants, right? So what happens when you do this, when you take this approach of controlling an consultant, is that a consultant in the eyes of law is actually an employee. So, and if they're an employee, you should have been paying benefits on their behalf. Now, generally, each jurisdiction has a different way of looking at this issue. If you were somewhere in the US or Europe, then this is a very big ticket item. But in India, it's not so much. The issue is largely on what happens if the consultant sues the company, saying that essentially he or she was an employee and the company should have been making welfare payments. And an authority in question looks at the facts and they come to the conclusion that yes, indeed, the company had a sufficient degree of control. So in these scenarios, then the lawyers agree that from the 100 million purchase consideration, a certain portion of this, which could, the lawyers will calculate what the total liability could be if an authority were to find that there has indeed been a violation and welfare must have been paid. So they'll calculate that welfare. I mean, the lawyers themselves won't calculate it. They would hire an labor law consultant or an expert to make that calculation. Either it would be held back from the purchase consideration, or it would be a specific indemnity. Specific indemnity means it's a mechanism in a document. It's a legal concept, and a person incurring loss should be able to claim loss from the person who has caused that injury or is directly responsible for the loss. So a specific indemnity for that entire cost that could be paid on behalf of the misclassified consultant would be held back. And all of these issues, once you find a process to fix them or codified into the document in such a manner that completion of each of these actions triggers or unlocks a mechanism which is closer to payment, right? So if, let's say, this is the timeline of the transaction, and let's say obviously if you want deal certainty, all parties have to sign the document for deal certainty. But once you sign the document, while it assures deal certainty, the seller has to do all of the items between 1 and 3 to fix the issues that they see, right? Then as they keep solving, I'm going to do issue 1, issue 2, and solved. Okay. Then as these 3 issues are solved for as conditions precedent to the transaction. So once all these 3 issues are solved and lawyer for A verifies the solved issues, it triggers payment. Okay. Payment date. Okay, all the issues are solved. Lawyers of A have verified that all the issues have been solved. So, and then automatically, once these 3 matters are solved, then A is now obligated. It's not, well, they may make the consideration now that they're satisfied. They must make payment once that's why it's called deal certainty. And that's how these agreements are structured. And then they'll have to transfer the 100 million. So the day on which this 100 million is transferred, the lawyers for A have verified that all of the issues that they identified in the diligence or solved for is called the closing date. You must have heard this a lot when you are around corporate lawyers. Closing, closing, closing. So what they mean by closing is that's the date on which all of the issues that they've identified in a DD report have been solved for, all the risks that they've identified from on the target have been mitigated to a certain extent and also factored into the document, and payments have been made for this day to acquire the company, or payments have been made to invest in a business. And this is how thinking like a corporate lawyer works. We'll look into more frameworks, more practical tools that will get you in touch with real practice of law while you're in your near final years of law school. Or it will also, these exercises can also help you understand or relate to your internship experiences better, right? A lot of you who are going to a corporate or transactional law firm for an internship will never do any of the decision making. You will never get to see, I don't know of any intern who's gotten into this, who's been given a task to look at the issues identified in a DD report and make a determination on how this is going to be solved. At best, you will be called on to look at the law and identify if it's given a certain set of facts, if it is an issue or not. But you won't be asked to make a decision on how to fix it. In fact, you shouldn't be asked, because you don't have the experience, and you could give an incorrect answer, which could cause a great deal of loss for the client. This is something someone with experience must do. Now, I hope this video at least gives you context in the nature of tasks that you're doing if you are in a law firm. So we'll do more of these videos. We'll also look at the litigation side of things, and slowly we'll also get into how you can think of diligence, and also how you can think of documenting all of these. These are very interesting parts. So until the next video, hope take care of yourself, and please do give us a shout out in the form of a like and comment on our videos to let us know if you want to learn something else. Thank you, and have a great week.